Welcome back to LAWSTACHE channel. My name is Anton Vialtsin. I'm a criminal defense attorney in the Southern District of California, here in San Diego. A few years ago, there were a bunch of news made about militia groups trying to work and apprehend illegal aliens at the southern border. And there were a bunch of questions whether that work was legal or whether they were impersonating Border Patrol agents. In fact, if you go on YouTube or Google some of these groups, you can even find interviews by the defendant in this case. Now, a few days ago, the 10th Circuit finally published their opinion about this particular case and whether United States Border Patrol and the word Border Patrol are synonymous. So let's take a look at this case and look at the legality of what these militia groups were doing. In this video, we'll be discussing United States versus Benvie, a 10th Circuit case that's fresh and hot off the press. In fact, it was published on November 18, 2021, just a few days ago, if you're watching this video when it comes out. And if you're not, I encourage you to subscribe to my channel and click that bell notification button so next time I post, you're the first to know, and this way you can get fresh information. As always, we're first going to discuss the background information, and then we're going to talk about the law and what the 10th Circuit says. But if you're interested, I also encourage you to put James Benvie's name in the search on YouTube, and you will find a bunch of videos, a bunch of news videos, and even some interviews with Mr. Benvie. And you can make some of your own decisions whether what he did was legal or illegal. Now, here's what happened. In early 2019, he was what you can call a leader or at least a member of United Constitutional Patriots. And they were camping out on a 52-mile stretch at the U.S.-Mexico border in New Mexico. Now, they were patrolling this area trying to apprehend illegal aliens. On April 15, 2019, he approached a number of aliens crossing the border. He yelled at them, "Alto," which means stop in Spanish. And then he eventually yelled at them, "U.S. Border Patrol." Now, this is the first incident that we have on video. And in fact, at trial, the jury was able to watch this video. Now, the second incident happened on April 17, 2019, just a few days later. There, a number of aliens again crossed the border. Mr. Benvie yelled "Alto, Alto" at them, trying to stop them. When they ignored him, he then yelled out "Border Patrol." These are two incidents. He gets prosecuted for impersonating government employee under 18 U.S.C. section 912. He goes to trial on this charge. At trial, the government uses the videos of these two incidents and Border Patrol agents' testimonies. There were two agents that testified at this trial. And Mr. Benvie himself also testified. He said that when he was saying Border Patrol, he was telling the aliens that he's able to connect them with the Border Patrol. He was not, in fact, himself a Border Patrol agent. He was trying to describe this as though he's a ticket scalper outside a stadium. That's his own words. That's how he was viewing what he was doing. Now, during deliberation, the jury asked the judge whether United States Border Patrol, U.S. Border Patrol, and the words Border Patrol carry the same weight legally, whether it's the same thing, because he is saying it in a different way. The jury answered that yes, these two terms are in fact synonymous. Now, this is over an objection by the defense. His attorney said, no, these two terms are in fact different, and they carry different meaning. So now we're going to go to the appellate court because Mr. Benvie loses a trial and he gets sentenced to 21 months in prison and gets a bunch of conditions of supervised release to follow. Now, when we get to appellate court, we're only dealing with a few questions. One of them whether the judge was correct when he instructed the jury that these two terms are in fact synonymous. So let's take a look what the 10th Circuit does. Sorry for this quick interruption, but can you do me a huge favor? Can you click that subscribe button below so next time I post, you'll be first to know? And then can you pause this video and call at least 2 friends, or maybe send a text message sharing my video with them. Tell them, hey, I'm learning so much from this channel. It is wonderful. Tell them to subscribe. And of course, I thank you for subscribing and watching. Thanks a lot. We're back to the 10th Circuit and their opinion whether the trial judge was correct when he instructed the jury that the terms United States Border Patrol and Border Patrol are synonymous. So here's what the 10th Circuit says. When we look at the trial, the terms were used interchangeably. Both of those terms carried the same weight. And in fact, until the jury asked for further instructions, nobody made that factual distinction, neither the prosecutor nor the defense. Then Mr. Benvie himself, when he was referring to the federal agency and the federal agents, he referred to them as Border Patrol 75 times. He didn't refer to them as United States Border Patrol. He simply called them Border Patrol over 75 times. Defense theory and the testimony would be undermined if they had different meanings. What does that mean? Well, let's take a look at the testimony. He said that when he was saying Border Patrol, he was telling them that he could connect these aliens with Border Patrol. Of course, he meant that he can connect them with United States Border Patrol. Otherwise, his testimony would not make any sense. And finally, if we look at the Supreme Court and the opinions that have been published by the Supreme Court, it seems like these two terms are often used interchangeably. Because of these reasons, the 10th Circuit says that unfortunately, Mr. Benvie loses again. These terms are interchangeable and there was no issues at trial when the judge instructed the jury to that matter. And finally, there were a couple other bonus issues that I'll give you. One of the conditions of supervised release was drug testing. Now, at sentencing, the judge orally told the defendant that there would be no drug testing. But when he got the written order, the box was still checked for it. Now, as a bonus, I will tell you that the oral pronouncement always takes more control over the written. So we just have to correct the record. And then finally, the supervised release conditions that the judge said, the 10th Circuit asked the trial judge to again give an adequate explanation how those are relevant to this case. Now, there's nothing that's required too specific, but the judge has to at least explain why he's giving those supervised release conditions. If you enjoyed this video, if you now understand a little bit more about United States Border Patrol versus Border Patrol, if you found this video interesting, I ask you to like, subscribe, hit that bell notification button so next time I post, you'll be first to know. And if you'd like to purchase the Do Not Arrest Me t-shirt, you will see the rest of the video gives you instructions on how to go on my website and get one of these awesome t-shirts. Thanks for watching.